Okay, so if you saw my last ones on Cornell Law, if you didn't get a chance to check out my first two videos, you might want to do that. Otherwise, thank you for viewing my channel, and please like this video, please subscribe to this channel, and thank you for coming with me on this journey. I am in the process of studying law at Cornell University, and I just thought that I was doing it, getting through it on my own, but then I decided, to kind of build a community around it if I can. If you are a student at Cornell or studying law, please like this channel and subscribe to the channel, hit the notification bell, and let's be friends. Okay, share this video, okay, and leave comments below. Okay, so this one I mentioned on the previous video that I was going to be doing the glossary because I love vocabulary words. I absolutely do. And a few of the things that we went over, I've heard of them before. Like I studied real estate appraisal and law of agency, and also in insurance, we covered umbrella policies that cover things like riots, floods, earthquakes. It's an umbrella policy. So like with your homeowner's policy, you may have for burglary, right? What else? Home fires, starting the kitchen from cooking, different things like that. If someone has a slip and fall on your property, your homeowner's insurance policy will cover that. Well, in addition to that policy, you might want to get an umbrella policy, and that umbrella policy covers all these other risk factors that you never think about. I mean, when I was in class and we're talking about riots and insurrections and terrorist attacks and um, uh, an attack by the KKK, burning a cross in your yard. Oh my God, insurance, insurance, insurance. I learned so much. Insurance, real estate, and of course there's some legal parts in all of those. But now I'm actually into the law part at Cornell Law. So again, thank you for viewing this video today. I hope you watch it to the end. We're going to knock out some vocabulary, okay? So this is one, acts of God. That's also is under that umbrella policy. I love that concept because it gives you a good visual of what that does. I just see a huge umbrella over your life that protects you from all kinds of stuff, okay? So the first term is acts of God. That is natural disasters or other events outside of human control. Agreement to agree. An initial agreement in which the parties indicate their intention to negotiate and develop a formal written agreement. That's the part where you want to make sure that you don't make some promises, be careful during negotiations, And a lot of people will throw in different promises and stuff like that just so they can get the deal. That's, be very careful making promises. Okay, so, and a lot of times this is why you do not negotiate with someone that you are going to go into a contract with. You let your attorney talk to their attorney and you remove yourself from that situation so that you are not tempted to get in there and say thus and so, this and that. Now you can be in the room, but you allow your attorney to speak for you. Okay, so that's kind of, to give you an idea of what goes on. From what I've heard in the music deals, Many times, the same attorney who represents the company, Sony, whatever, 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 fill in the blank, um, they also represent the artist. The artist does not have their own independent counsel. They are being represented by the same attorney as the company that they are signing their record deal with. That is so bad business. And the artists who get the best deals are the ones who have family members or cousins or in-laws who are in um, the legal field, who can represent them separately from the company to get the best deal for them. Okay. Okay. Allocation of risk. That's a big one for me that I really liked, because again, the unknown looms large in my mind, you know. And when you have a contract, you really want to make the contract where you are covered for unknown things that may happen, that, you know, oh my God. And again, that's why I love umbrella policies, okay? Allocation of risk. The assignment of legal responsibility to a contracting policy for an event or the non-occurrence of an event. Something that you needed to happen that did not happen. And I know right now there are so many conference rooms and Zoom calls with legal people behind COVID-19 and what happened and what didn't happen, and I didn't make the money and I can't make this agreement. And blah, 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 blah. It's just crazy. It's just crazy right now. I know it. Oh my God. Baskets. Under a basket, the indemnifying party does not have an obligation to indemnify the beneficiary until the amount of the beneficiary's losses exceed a certain amount. Right? Generally speaking. Okay, so that's an example of that is an auto policy. So if you have a full coverage insurance, you have a deductible. That deductible has to be paid before the insurance policy coverage kicks in. So if the damage to your vehicle is less than your deductible, then the insurance company is not even into it. You just take care of it yourself, okay? So you are the beneficiary. You do have a loss, but it does not exceed your deductible amount. Okay, so that's the basket. The basket. Under a basket, the indemnifying party, the insurance company in this case, does not have an obligation to indemnify the beneficiary or you until the amount of your loss exceeds your deductible amount. And usually you pay the deductible, whether it's $100, $200, $500, $1,000, and then the insurance company will kick in for the remaining amount. So even though your damage does exceed your deductible amount, you pay the deductible first, and then the insurance company will take care of the rest. All right. Let me know if I went down the wrong path on that. Okay. Let me know, but that's the way I'm thinking that it is in my mind. Okay. And so it says, generally speaking, baskets are I'm right. Generally speaking, baskets are structured either as a deductible or as a threshold amount. A tipping basket that, once reached, obligates the indemnifying party to pay the total indemnification amount. Baskets may also combine features of those two. Okay, makes sense? If you have any questions, leave them down below. But I try to make it understandable, not just, you know, because I can't change my brain, right? It has to make sense to me in a practical way. How can I use this knowledge, the law, in a practical way in my life? Because the law is all around us. It's in so many things that you wouldn't even think, but it is. Closing. The final, uh-oh, a baby crying. Closing. The final step in a formal transaction at which agreed assets and/or liabilities are transferred in exchange for agreed consideration. That's the closing. Okay? The final step in a formal transaction at which agreed assets and/or liabilities are transferred in exchange for agreed consideration. And consideration usually means money. Okay, so when they say closing costs for a house. So when you are paying your closing costs, that means that you are closing on this property, okay? And whatever your down payment is, whatever, whatever the particulars are, the specifics in your mortgage contract, you are taking care of that. This is the closing. And usually you meet at either the mortgage company, the bank, or the real estate office with your real estate agent. You sign the final paperwork, you do whatever it is that you're supposed to do, and you get keys. Sometimes they will even do the closing at the property itself, so the agent will meet you at the property. You will do your closing, all of that, sign the paperwork, all of that, and they give you the keys and they're out of there. And they leave you there at the property, okay? So that's the final step in a formal transaction, closing. Conditions to closing. Conditions that must be satisfied in order for one party or the other or both to be obligated to close a transaction. And normally that's when people will tell you, when you're buying a house, do not go out and buy new appliances. Don't do anything to mess up your accounts, like the balances in your accounts and stuff like that. Just leave that alone until after closing. Okay. And a lot of people are not told that. Okay. Consequential damages. Losses that one party to a contract incurs as a result of another party to the contract failing to meet contractual obligations. Okay. Consideration. Something of value that is exchanged for something else of value. In a contract, the contracting parties provide consideration to each other. Okay. Contingencies. The variety of events or situations that may arise after a contract is signed, which a good contract should foresee and address. That's the thing. Oh, contingencies. If-then statements. If this happens, then this will take place. And that's in the contract, okay? Contract, an agreement between two or more parties that is enforceable by law. Covenant, a contractual promise to take or refrain from taking a certain action. And you will find covenants normally in your homeowners association contract. If you break a covenant, a lot of times you will hear that HOA took a person's home because they broke a covenant. Okay, so look into that. If you hear that, whether you're buying your condo or you're buying a home, it's on a golf course, they have a homeowners association, please look over those covenants. Okay. Damages, losses that a contracting party may recover after a breach by the other contracting party. Okay. Damages. Detrimental reliance. This is a good one. A situation that occurs when one party suffers harm as a result of relying on the unfulfilled representation or promise by the other party. Oh my God, you will hear that, and it every filing for divorce, you are going to see that. Detrimental reliance. I relied on this person to my detriment, and I need to be compensated for that. Child. Oh, a situation that occurs when one party suffers harm as a result of relying on an unfulfilled representation or promise by the other party. Ooh. Be scared of them. Disclosure schedules. In an acquisition agreement, lists of the assets and or liabilities to be transferred and or exceptions to representations and warranties contained in the agreement. Okay. Due diligence. This is a big one. This is, this is the job that I always wanted to have as a due diligence underwriter. I always wanted to do that. I always wanted to do that. It never happened, but anyway. Investigations conducted prior to the signing or less commonly closing of a business agreement with the intent of assessing the value of the transaction. That's, again, these are the people who will get you every time. If you go to buy a house and you are over there at Fingers and you are over there buying appliances and stuff and artwork, and then you go over there to Mattress Mat and get your bedroom suit and your living room suit, honey, and all of that is hitting your account. So that's going to change your standing. And the due diligence underwriter may deny you on getting that loan because your assets have changed. Your money in your accounts and stuff has dwindled. So you no longer have the same standing that you used to have. So they're gonna, that's a no. So be aware of that. Even if you're using your credit card in order, just don't do any of that stuff. Don't do any of that stuff when you are doing a contract. That's why a lot of people, even in a business contract, let's say you're doing a business deal and your company is in the black, it's totally in the black. Then you've got one of your directors or managers um, um, runs over somebody or gets into a accident and there's a vehicular homicide charge on that person. That's going to make your company look bad. That's why you do your due diligence in checking out a person's criminal background, making sure they're not on drugs, that type of thing, because if they are, then that's going to negatively impact your company and may keep you from getting additional business. It may cause you a problem if you're deciding to go public as far as being able to get investors. It's a problem. It's a problem. But a lot of people will hire people like that because they like them. They like them. But read, that person is a bootlicker, a butt kisser. They're not qualified to be in that position, but the boss likes them. And normally that's what causes a lot of problems. You really want to stay professional in what it is that you're doing. But if you don't, it's fine because it's more business for lawyers. You know, lawyers and attorneys love when you make bad decisions. Love when you hire people that you like, people who have questionable backgrounds and they get into some tomfoolery and it costs you. And then you have to call them in order to get your situation straightened out or whatever that you need to do. It's more business for them. Can you say it with me now? Billable hours. It's fabulous. All right. So that's due diligence. Do yours. Earn out, a type of post-closing price adjustment that modifies a purchase price paid in a transaction on the basis of certain performance criteria. Here's an example. There is a movie, oh my God, what is it called? Anyway, it's a movie about this plane that went missing for 5 years. But the people on the plane only felt turbulence and that was it. Two of the people on the plane were very significant. One was a scientist and the other was a little boy with leukemia. The lady who was a scientist, her research was able to get through, and because of it, they were able to help so many children with cancer. And so the company was going public, and it was going to be a lot of money. So then you had this little boy who was on the plane with her. Um, he wanted to be a part of this program, and they voted on it with a no to let this little boy die because they were going public. And if he was to die, if her research did not cure his cancer, then the company would take a hit on that. And so the answer was a no. The answer was a no to let that little boy die, rather than jeopardize their earnout. Okay? A type of post-closing price adjustment that modifies the purchase price paid in a transaction on the basis of certain performance criteria. See, they had a really good record of curing everybody, and they did not want to take the chance that this child who had been missing for 5 years but had not aged, plus had leukemia, it was too many variables, and they didn't want to take the hit. Earnout. Enforceable. Ability, able to be taken to court to compel action as an enforceable contract. That speaks for itself. Okay, expectancy damages, compensation given to an injured party after a breach of contract, intended to restore the injured party as good a position as if the contract had been performed as promised. So again, this is to indemnify the person. It's kind of like an insurance policy. Okay. Intrinsic evidence that is pertinent to a contract but is not found within the contract itself. Force Mahu, I'm not saying it right. Oh God, I'm not even going to try to say it right, you guys. Hold on. A provision in a contract that frees the parties from their obligations in the event of an act of God or other occurrences beyond their reasonable control. Okay, force majeure clause. I'm just going to call it that. Gap fillers. Contract terms supplied by a court when a contract fails to deal with an important matter. Gap filler. Illusory promises. Language that does not constitute a promise because of the lack of commitment. Indemnity, we know what that is. To restore a person. That's an insurance term. Information gap. A certain lack of knowledge that one contracting party may have about the other party, or about the item that is the subject of a transaction. By identifying information gaps, the parties can work to draft contract provisions that provide the information, assurances, and adjustments needed to address such gaps and create a successful contract. There's something I want to say about that, but I'm not going to say it, okay? Knowledge qualifier. A qualification in a contract, typically to a representation or warranty, which states that certain information is based on the knowledge of the person providing it. Okay, any questions? Questions? No? Okay. If you have some, let me know, okay? Liability, financial or other responsibility of an individual or organization, okay? Liquidated damages, money or other compensation that will be paid to an aggrieved party in a contract dispute under a provision included in the contract itself. Okay. Materiality. A qualification in a contract relating to the extent to which a fact, action, or condition that has been qualified is significant to the value of the transaction. Okay. merger clause. This was a big one back in the 90s. There was a lot of mergers and acquisitions. Um, just so many moving parts. Coopers and Lybrand and PricewaterhouseCoopers merged. Then Mellon Financial uh, acquired a line of service from PwC and then sold that line of service to Buck Consultants. It was just crazy. There was a million mergers and acquisitions going on. And I'll tell you one that's just recently happened. KBR just acquired Centauri. Yeah. Yeah, that just happened. It's pretty exciting. We'll see what will happen with that. But that was just a recent acquisition that just happened. And I was just like, what? That's amazing. It wasn't a merger, it was an acquisition. Check that out, okay? So, merger, a provision in a contract stating that the contract represents the complete and final agreement, that it supersedes any prior agreement. Okay? Post closing price adjustment. Okay, so this is post closing price adjustments. Okay, a contract provision that provides an adjustment of the purchase price in a transaction on the basis of certain agreed criteria. I will pay this price for this house if you agreed to that you were going to change out these lighting fixtures for me. So that's in the contract that you were going to do that, and because you did that, then I was going to pay a higher price. Okay, we agreed on a higher price because you were going to do this. So I need you to do that. And if a person says, well, I can't do it, then we're going to have a price adjustment after closing, right? Post-closing price adjustment. Remedies, judicial methods for making a contracting party whole after a contract has been broken. Okay? Representation, a statement of fact. Signing, the act of putting signatures on a contract indicating that the parties have read the agreement and intend to carry out its provisions. That's pretty straightforward, right? Statutes are laws passed by a legislative body. You know, we have a lot of statutes that are before the legislature now, and there are city, county, state, and federal legislatures. Okay. Tort. You've heard of that, tort reform. Well, here's the definition of a tort: an act or omission which causes harm or injury to another and which does not involve contract or criminal law. Okay? You have any further questions on that, let me know. All right. Statute of frauds, legal requirement that certain kinds of contracts be set out in writing. Okay. Statute of limitations, you know what that is. I hate those. I hate statutes of limitations, but you have to have them. I just really hate them, especially for wrongful death. For wrongful death, you have the statute of limitations for filing that is 2 years, which I hate that. I hate that because usually when you're in the process of grieving, you are not in the right mindset to be thinking I need to sue somebody. Normally, there are certain people who are very litigious and they want to sue for everything, okay? But for other people, especially like I said, when it comes to the death of a beloved member of your family or whatever, you're just so broken up, you're not thinking about filing a wrongful death claim or a case. You're not thinking about that, hiring an attorney and going through all of that. You're going through your emotion and grief and Anyway, I hate statutes of limitation, but there it is. A statute that prescribes a period of time after which certain rights cannot be enforced by legal action or offenses cannot be punished. That's the other side of it. The statute of limitations. I think the only crime that does not have a statute of limitations is murder. Okay, but again, it's you have to look at state laws and stuff. It's just a quagmire. Good luck with that if that's what you're having to deal with. Okay, my heart goes out to you. Okay, so then we're moving on to termination provisions, the portion of a contract that specifies the conditions under which the contract may be terminated. Okay. Warranty, a contractual promise that a certain fact is accurate. That is the warranty. I warrant that the sun rises every day. And it does. Okay, so that is all of the vocabulary on this module. If you have any questions, do not hesitate to send those to me. Comment below. Let's all help each other in this, okay? And if you are wanting to get together to discuss anything, we can do Zoom, we can do Microsoft meetings, one-on-ones. Let's kind of, iron sharpens iron. Let's apply that principle here, okay, so that we can all become better. You guys, your input is very important, and let's build a community around this, okay? So again, this is vocabulary. It is Cornell Law School, Cornell University, and this is contract law. All right? Thanks so much. See y'all next time. Bye.